Decision. Shannon Bream joins us now live outside the U.S. Supreme Court with more. They have made some changes to the way that the Voting Rights Act is viewed. Shannon, what can you tell us?
Well, Martha, for folks just to remember what this is about, the Voting Rights Act was passed back in the mid-1960s, and it's all about remedying discrimination against minority voters. It was passed so that certain covered jurisdictions, there are several states, a number of other chunks of states, where there's been a history of discrimination in the past, and because of that, if they want to change voting procedures, they have to go to a federal court or the Justice Department and ask permission first. A number of these states have argued it's time-intensive, it's very expensive for them to do it, and that things have changed over the years. Section 4 of the Voting Rights Act is the one that figures out or calculates which is going to be a covered jurisdiction. In an opinion by the Chief Justice, they have just called Section 4 unconstitutional, saying nearly 50 years later things have changed dramatically, and largely because of the Voting Rights Act, voter turnout, registration rates in covered jurisdictions, essentially under a penalty, and have to get national approval from the Justice Department or a court, federal court, to change things. They say things are now approaching parity. So Section 4 now found unconstitutional, meaning it could change